Hello, and welcome to Fort Vancouver Regional Library's 2024 Revolutionary Reads series. This year's series focused on the book Free: 2 Years, 6 Lives, and the Long Journey Home by Lauren Kessler. This year's program was built in partnership with our community organization, the Foundation, Restore and Prepare, and is made possible through generous support by the FVRL Foundation. Thank you for your interest in this program, and as always, thank you for using your public library. Revolutionary Reads is an annual community reads program with the goal of galvanizing the Southwest Washington community to read the same book on a topic of revolutionary importance. Revolutionary is defined as involving or causing a complete and dramatic change, and or radically new or innovative, outside or beyond established procedure, principles, etc. The 2024 program focuses on the experience of incarceration and reentry. This series will explore the challenges, systems, and supports that exist in Southwest Washington for those returning home.
My name is Mia DeMay. I'm the volunteer manager at the Clark County Volunteer Lawyers Program. We'll do introductions and then I'll kind of talk about what we do and then turn it over to them who are much more interesting than us.
My name is Robert Sellers. I am a eviction defense attorney with the Clark County Volunteer Lawyers Program.
And I'm Ben Moody. I'm the Housing Programs Managing Attorney at CCVLP. So I run our eviction defense program as well as our non-eviction housing advice program we call Housing Justice Project.
Yes, there's a lot of acronyms, as you learned, HJP, CCVLP, so we will try to break those down. But to kind of talk about what our program is, I'm sorry, I'm gonna be just staring right at you because you're like the person that keep realizing, so I'm gonna try not to, but so our organization is, we provide free civil legal advice to folks who can't afford it or otherwise access it. You, sweet person, guess how much the hourly rate for an attorney is? Just like 1 hour, how much do you think it costs?
Oh, it's like $250, $300.
Exactly, yes. The average hourly rate in Clark County right now is about like $250, closer to $300 from what we can tell. So obviously lawyers are very, very expensive. And I always tell folks, everyone has seen at least one episode of Law and Order or something in their lives. And you'll always hear, you know, if you can't afford an attorney, one will be appointed to you. That's only for criminal issues. So things that are civil, whole other plethora of issues. So things like divorces, custody, evictions, you know, filing for bankruptcy, even getting your name changed, doing things like that. It's all civil, the civil side. And so basically you are either to figure out the legal system yourself, which is called pro se, so you're representing yourself, or you have to hire someone to help you through the process, which, as we talked about, is very expensive. And, you know, often things like family law cases, those go for years and years. So you can quickly see how that will add up. So our program is to, you know, fill that need so folks don't have to go and pay for attorneys. Another thing is that even if you're pro se, so you're acting as your own attorney, or if you have an attorney representing you, no matter what, you're held to the same standard in the court. So here's this sweet, sweet attorneys who have gone to law school and have all of this knowledge. And then little old me, could be up there and the judge is gonna expect us to, you know, do the same, you know, act accordingly, which is not very fair. And so again, that's the reason why our program exists, is to kind of step in and provide assistance to folks who, you know, can't normally afford it or access it. Also, we realize the legal system is not always accessible to all people or genders or races. And so there's additional barriers for some folks to accessing legal services. And so our whole, you know, point is to make justice and access to justice the same for everyone, no matter what their standing is. We have programs in housing and family law are definitely our biggest. Housing, I can turn over to them to kind of talk about, but here, go ahead. You want to talk about housing?
Sure. Currently, eviction is the one area where you may be appointed an attorney in civil law as opposed to criminal law. It's because under state law, if you're, the term they use is indigent. Basically, if you're low income or receiving various types of benefits and you're facing an eviction as a defendant, you can qualify for a free attorney to represent you in your case. And that's what our office does, along with a couple of other organizations locally and around the state, where we are there every week at the eviction dockets, looking for new clients, it is absolutely free to all of our clients to get an attorney who will defend you in your case or help you with negotiation, point you towards resources, all sorts of things like that. My group also provides non-eviction advice clinics. So if you just have an issue with a landlord, a question about your rights, a problem with a neighbor, and you need to know what your legal standing is, then we can get you an appointment with an attorney. That's a largely volunteer staffed program. But they can sit down with you or talk to you over the phone or Zoom about what's going on. And Rob is one of our staff attorneys for eviction defense. So he's like a public defender for evictions. Similarly, he's also done some misdemeanor work in the past.
Yep. I 2 years doing criminal public defense, and then in law school, I had 2 years clerking in various public defense, criminal public defense situations.
So I'll have some interesting stuff to talk about later. But yes, I like how you said that. I also equate it, it's kind of like a public defender for evictions. And it's really interesting. I've gone to the docket and I've watched them, and they really do. They say, like, raise your hand, who here is getting evicted and doesn't have a lawyer? And there's like, people, and they're like, cool, I am your lawyer. Come on, let's go meet. So it's pretty amazing. It's a really cool, Washington is very cool because of having that law. So yes, that's our housing aspect. And Ben also kind of touched on an important thing about our program is it's all, primarily it's volunteer run. I was gonna say all, but then I realized I'm sitting next to 2 staff attorneys. Predominantly the services are given by volunteer attorneys. We do have some staff attorneys, but what they do is a little bit more specific. So it's not like you have to have a 14-day notice, or you have to have, the thing saying you're getting evicted for one of our staff attorneys to step in. Similarly, we have a survivor support program. So it's basically it's standard family law issues that have high rates of domestic violence or maybe high urgency needs. And so we have a few staff attorneys that do that, but again, it's kind of specific. It has to meet certain qualifications. So how many RTC attorneys are there?
There's me and there's 3 staff attorneys, and we're adding a 4th in July.
Yeah, so 5 in their area, so the eviction defense. There's 1 in our housing, so the just general housing issues. And then now we have 3 in survivor support, and I think that's it. So yes, we do have some staff attorneys, which is lovely, but then everything else, all of our other programs, any other way that we're giving services is just by volunteers. So local attorneys will, out of the kindness of their own hearts, volunteer their time, and then we will schedule clients accordingly. So it's all very based on what the volunteers can give us. So they're still lovely and great, and it's better than nothing. But they do give you advice only, so our attorneys don't go to court with you. But folks can get multiple appointments with us. They can kind of, be let loose. The attorney will say, go work on these things, and then come back to us and you can get another appointment. So that's pretty typical of, we see a lot of recurring folks, and we just kind of see them through our programs. Sometimes because we are dependent on volunteer attorneys, sometimes we have to close certain programs if we just don't have those attorneys volunteering in that area. So typically we are closed right now to record vacating, elder law, general law, and debt defense. But if folks call our office with those specific issues, we will still give them resources for other places in the area that might be able to help. There are a few other places where outside of us where people can reach out to get legal advice, that we'll send them there. So we always say, even if we can't help, we can give you some sort of resource or something. But that's generally how our program works. But yeah, so that's just us in general. So I will say, we are not the criminal side. So I know a lot of this book that everyone is talking about is more the criminal side. So we're a little bit limited, but luckily Rob was a public defender at one point, and law is law. So they know some stuff. So we did take some of the questions that you all sent us in advance. And you just want to kind of say the question and then go through it?
Yeah, there was a question that I was able to get some information on that was sent to us in advance, and that was basically, can landlords check my criminal record when I apply for a rental, and what's the impact of that? So in Washington, yes, a landlord can do a background check that includes your criminal record, and that can factor in to their evaluation of applicants for who they're going to rent to. There's not a specific law on how far back that goes, what the criteria they use are, but there are related laws that give us some information on this. One, a landlord does need to tell a prospective tenant, either before they apply through writing or by putting it on their website, something like that, what the criteria they use are for deciding on applicants, and also what sort of information they're going to gather. Once they've done that, it's a little bit complicated because the main law that we're dealing with is actually the Fair Housing Act, which is a federal law. The Federal Department of Housing and Urban Development, HUD, has issued some guidance on what they believe the implications of that law on this question of criminal records are. And what that guidance says is that a landlord shouldn't have a blanket ban on people with anything on their criminal record renting from them. They can still use it to decide maybe someone else is more qualified, but they can't outright ban it. And the reasoning for that is because we know that conviction rates are strongly correlated to protected classifications like race. And there's what we call a disparate impact. If you banned people who had convictions, you would be to a much greater extent banning people of color than others. And so the guidance is no blanket bans. The landlord should ask for the specifics of what the history was, the severity of the offense, how long ago was it, any mitigating circumstances, before deciding if they're going to rent to somebody who has something on their criminal record or not. That does leave you in sometimes a bit of a tricky situation because it costs money to apply to rent. So oftentimes it's best to be upfront about that and find out what a landlord's opinion is. Will they really consider you? Are they going to ignore the law? Because to get some sort of compensation because a landlord did discriminate against you this way is really hard. And from a practical standpoint, finding out first if you're wasting your time, effort, and money may be the way to go. But then you could also talk to that person and explain the situation, how long in the past it was. Here's some references I have from other people more recently, things like that, or just the general situation. There is a exception to this idea of no blanket bans because the Federal Fair Housing Act does not apply to people with convictions for manufacture or distribution of controlled substances. So those convictions, they can have a blanket ban on. Now, again, this gets nebulous because none of these are cases that the courts have decided and said, yes, this is correct. This is what HUD believes is how the law works and should be applied. Well, there's another law that we can look at in Washington, and that's called the Washington Law Against Discrimination. And it also has a lot of the protections that the Federal Fair Housing Act has. And it says that you can't discriminate against people for a variety of categorizations. It does not specifically have that same exemption for drug convictions. So theoretically, even if a landlord was acting in compliance with the Fair Housing Act and banned anybody with a drug conviction, at least not possession, it has to be a manufacturing or distribution conviction, theoretically, that could be a violation of the Washington law against discrimination. So again, a potential avenue for getting in with a landlord, but it is going to be difficult because they can look at that record. Now, if a landlord does reject someone because of something they found in their background check or a rental history report that they got, they do have to inform you of that. They have to give you a written report about their, what we call an adverse decision, that explains why they rejected you from an application. So if you are running into that problem, and if a landlord hasn't given you that, ask them for it, or demand it, but ask them for it, get it from them, and find out what's in your history. And if it's something that they're not allowed to discriminate against, maybe you can then, with a stern reminder about that violation of the law, get in there. Or maybe it's just going to reveal something else. Because oftentimes you look in that and it's like, no, you didn't meet the income requirements. Or you told us that you didn't have this on your record and you did. Because one thing they can absolutely reject you for, or even evict you for if they find out later after they start running to you, is if you lie on your application about something important, something serious, or that would have affected their decision to rent to you or not. And one other thing to note on this question is being arrested or charged with a crime is not a basis to deny someone an application. Even if it were one of those drug crimes, those are about convictions. An arrest or a charge does not prove you've done anything. So if you ever run into that, that would be an improper rejection of an applicant if you ran into that. So yeah, that's my spiel on that particular question.
I have a question on that. You said an arrest would not be grounds for the denial of the application. Would an arrest be grounds for an eviction? Arrest alone?
Rob, you go for it?
Yeah, I'll take that. It can be, and it depends upon what the nature and scope of the alleged behavior is. So in the Washington Residential Landlord Tenant Act, there is a provision saying that if you behave violently on the property, that the landlord can evict you. And one of the things that says that can establish that you behave violently is an arrest for a violent crime occurring on the premises. But if the arrest were to occur off the premises, that for behavior that's off the premises, then no, it wouldn't be.
Does it have to be a violent offense if it's on the premises?
It doesn't have to be a violent offense, but it has to be an offense that is going to be an inherent violation of your responsibilities under the Residential Landlord Tenant Act or the lease. So we're talking violent offenses, destruction of the landlord's property, and distribution, manufacturing, possession of controlled substances.
That makes sense. Oh, I have a question. Also, please just say your questions as they come. We're very informal here. I have a question. What about, so for the manufacture of controlled substances, what about if the charge was related to marijuana and they now live in a state where marijuana is legal?
Yeah, it's more complicated, because federally marijuana is still illegal. And so especially if your property takes part in any sort of government program, like tax credits or housing subsidies, they may be required to follow all federal rules. And that would mean banning marijuana. Even if they are a privately held property, if it's in their rules, similar, they could have a no smoking rule, if there is a no smoking marijuana rule, then that could be a basis for an eviction. As for the Federal Fair Housing Act, I don't believe it qualifies what schedule of drugs or things like that are part of that carve out where they say, yeah, you're not protected if it's an arrest for, or if it's a conviction for this. So marijuana would also be, if it was,
Well, marijuana is Schedule 1, so that's
true,
also
yeah.
the highest level of the schedule.
Yeah, so if it were manufacture or distribution of that, that would also be one of those things where it's not protected under the Fair Housing Act.
See, I love working with lawyers, because I also just have questions.
Because every question ends with that depends.
That is true.
Yeah.
I just wanted to say, you also had some questions in your paperwork about sentencing guidelines in the state of Washington. The questions asked very, very complicated. And I could walk through sort of like scenarios if there was a specific question about something to the best of my ability, but but sentencing, particularly felony sentencing, is a very, very complicated topic.
Yeah, were there any specific along the sentencing? And I'm so sorry, I haven't read this yet, but maybe if there's like an example from the book?
Well, I think that's something that came up a couple of times in the book, is that several of the individuals in the book were children tried as adults. And then a couple of them, one in particular was unable to get parole because he had 2 consecutive sentences or something, so that he didn't qualify when it came around, but they were starting to reconsider children tried as adults. So could you talk a little bit about what you know about that at all?
Okay, well, and I've worked on cases like that before. And so you've got a couple of things that you just mentioned there. Almost every state has laws that allow certain severe offenses, like murder, attempted murder, arson, rape, to be tried as an adult. And that's, so there's 2 sort of quasi-criminal legal systems. There's the one for juveniles and there's the one for adults. And the juvenile legal system is sort of premised actually on the same idea in theory as foster care, in that it's trying to do what's in the best interest of the child. And whether it actually does that is a much bigger, more interesting question. But the adult legal system is about punishment and social control of unwanted behavior. So we don't want this behavior, so we're going to, stigmatize, punish, try and reform, try and deter. Deter specifically that specific person from doing that again, generally make noise and notice in society, so people generally don't want to behave like that. So there's 2 things specifically that you mentioned. The first is trying as an adult. So it's really specific to the crime, but for the most part, when you're talking about the juvenile system, in most states, you're talking about a system that's going to cut off at somewhere between 18 to 24 years of age. So it doesn't matter for what you were, it's not called convicted in the juvenile system. In the juvenile system, you're never convicted of a crime. You're adjudicated into the jurisdiction of the court. And that system's generally gonna cut off at 18 to 24 years of age. And so whatever happened behavior-wise to put you in that system, it's just going to end at some point. But if you're tried as an adult, you know, life without the possibility of parole is legal. Now, it's no longer currently legal for juveniles, but it's legal. The death penalty is legal. Like the level of penalty short of, you know, intentional torture for offenses under the criminal justice system is functionally infinite. So when somebody gets, you know, tried as an adult, they're not being put into the system that's trying to help them be productive members of society in the same way as when they're in the juvenile justice system. They're not in a system that has an inherent cutoff date. They're not, like, none of those things apply. Most of the time, that decision is made by the local prosecutors, the elected prosecutors and their deputies. In some places, and being in Vancouver, of note, Oregon has a law called, I want to say it's Measure 8, mandatory minimum sentencing. So in Oregon, if you are convicted, or if you're charged with certain crimes, it does not matter what age you are. If you're charged with certain crimes, you are tried as an adult. And so if you're on the listed crimes, rape in the first, second degree, murder in the first, second degree, arson in the first degree, assault in the first degree, you're tried as an adult. So it's just like, there's no option for the juvenile system in that environment. Now, the other issue you mentioned was consecutive sentences. So when people are tried for multiple things, they can be tried for multiple things at the same time. I guess the most topical, not to be a comment on it, but just one that people would recognize from the general news is currently former President Trump has been accused of maintaining possession of classified material. Each individual document that they identified could theoretically be a separate charge. And when you have multiple potential charges like that, either from the same course of conduct or from different courses of conduct, they can be tried together. And at the subsequent sentencing, the judge, depending upon the circumstances, usually has the choice of sentencing either concurrently or consecutively. A concurrent sentence is going to be a sentence where the time that you're in custody counts for both offenses. In a consecutive sentence, the time that you're in custody only counts for one sentence at a time. So if you have like 2 assault charges, you're accused of assaulting, say, 2 different people, and that you get 3 years for both charges. The difference between concurrent and consecutive sentences can be quite dramatic. So in the state of Washington, the standard is that 2 days of time in for good behavior counts for 3 days' time. It's what people are talking about when they say out for good behavior or time off for good behavior. So 2 days counts for 3 if you're following the rule of the institution in which you're being held. If you're doing concurrent time and working on both sentences, and both sentences have been charged at 3 years, then after 2 years of good time, then you can be let out of jail. But if you're serving one sentence at a time, because they've been charged consecutively, well, you just completed, after 2 years, assuming that you followed all the rules of the institution in which you're being held, you've just completed one sentence. And now, after completing that sentence, you start on day 1 on the other sentence. So you could get a whole nother 2 to 3 years, depending upon whether or not they think you're following the rules of the institution.
And Rob, do you know, is it generally your adult versus juvenile culpability determined based on the age you were when the crime occurred?
I mean, it can be, but that's also a very, 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 a very, very complex question. And the reason that gets into an even more complex question about criminal law, we don't generally punish people for what they do. We punish people for what we believe motivated their actions. So the most extreme example of this is killing somebody. If I intentionally kill somebody because I want them dead, that's going to be murder. If I plan it beforehand, that's going to be murder in the first degree. And a lot of governments in this country will try and kill you back for it. But if I kill somebody because I am being attacked, because I see somebody else being attacked, I'm still intentionally killing that person, but my motivation has now changed. And because my motivation has changed, it could be a lesser crime if I'm killing somebody because I feel imminent danger, but that belief is unreasonable. That could be manslaughter in the first or second degree. When you hear people talk about what is colloquially known commonly as sort of like the battered woman's defense, and those trials, that's often a situation. Self-defense tends to need to be an imminent, to be a complete defense. So there's oftentimes, those trials tend to be about whether or not the belief of like, it was reasonable to believe that danger was imminent, presently happening. And if I have a reasonable belief that I'm in imminent danger or somebody else is in imminent danger, then that's a complete defense in most states to killing somebody. The most horrible, simultaneously humorous example I've ever encountered of this was in New Jersey, where a guy was pulled over on the side of the road because his car stalled. A bystander came and pulled up behind him to help him out. And they both determined mutually that it was the person that was stalled just needed to jump. And so they hooked up the one battery to the other, and one person was standing between the two vehicles after hooking up the battery, and the bystander who'd come to help was in the driver's seat of their vehicle. And exactly, when they turned the engine and put the gas to charge the battery, the bystander's vehicle was in gear, and the person who was stalled got smashed between the two vehicles, believed that their life was in danger and they were being attacked, pulled out a firearm and shot at the bystander.
Oh my goodness.
I did not see that coming.
No.
And nobody intended to harm anybody unlawfully there. The only person that actually intended harm on anybody was the person getting smashed between the two cars. But they had a reasonable belief that in attempting to kill the person driving into them, that they were protecting themselves. And the person that that was smashing them, well, doing great physical harm to the person that originally been trying to get help, wasn't doing anything intentionally. It was just a mistake, which, you know, gets regulated. You know, if you've been injured in a car accident, call us and we'll get you paid for it, which gets regulated by the law, but it usually doesn't get regulated by the criminal law. So when we're talking about criminal law, we're generally talking about punishment by motivation. And then so to Ben's question of like age-related prosecution, there's usually a cutoff in the law. Sometimes it's statutory, sometimes it's what we call common law or constitutional law, which is to say that the judges have just tried to reason this out from logic, from interpreting the state or federal constitution, or from the tradition of common law going back to the UK in 11 or 1200. And then, so there's usually a cutoff, usually sort of depending upon the jurisdiction, usually around 7 or 11 years old, where we just say the individual isn't capable of forming the intent, the motivation that we're seeking to punish. So it doesn't really matter what they did. We don't believe that they've developed enough to actually have the thought process we're trying to stop.
I got a different question. I've had friends that got evicted so the landlord could make repairs or improvements. How does that work exactly?
Yeah, if you're on a month-to-month lease, a landlord might terminate your lease so that they can do improvements on the home. If they're doing a significant improvement, it needs to be 120 days written notice. If you're in the middle of a lease, they can't do that till the end of the lease, but that could also just be good cause for them not to renew the lease at the end of it. And they'd still need to give that 120 days notice. There are a number of enumerated good causes for terminating a lease. Ones where no one's at fault, need to wait until the lease is ended if you have that longer lease. Other ones are because the tenant has done something wrong, and those ones can be used to evict you and cut off your lease even if you have a loan. Does that help? I could go in more on those.
Yeah, I mean, I think it's fairly common, and I think I have heard anecdotally that evictions are way up because you can, right?
Yeah, I mean, there was the COVID moratorium for a while back in 2020. And since then, we've seen a rise in evictions, where we're hoping it comes back down, but life in Clark County is very expensive. And evictions are very high in our county because of that. Yeah, the whole thing with repairs are an interesting one, because you do have to have good cause to terminate someone's lease, except under very specific circumstances in Washington now. And so we do see pretextual attempts to remove somebody where they don't want to tell you it's to do repairs because they know there's a 120-day statute. But we also see it sometimes used where they'll give a repair termination when the reality is there is a fundamental problem with the building that the landlord knew or should have known about, and it's not really safe for habitation. And so they'll use that to move someone along at no fault, when in reality, if a landlord knew or should have known about a major problem that makes a place uninhabitable, they may have to pay you your costs of moving. And sometimes landlords try to avoid that by using this, one of these notices to terminate your tenancy. But what should have happened is you should have a chance to get an inspector out there to look at the place and say, no, this isn't habitable, and then the landlord needs to pay for you to move. But that process is complicated, and one of the difficult things we deal with in housing law is the remedies written into the law are often not great. For most things, if your landlord does something wrong, the main remedy the law gives you is to break your lease and leave. And that's not easy, that's not quick, that's not free by any means to do that. And other times when you do have remedies, you might lose them if you get behind on rent. So especially one of the main things I tell clients all the time is do not withhold the rent. The law almost never lets you do that, and even when it does, you either have to go through all this hoopla with repairs before and during that withholding, or you have to get an escrow account and pay into the escrow account. It's very complicated. So the remedies are tough, and landlord-tenant relationships are just that. It's a relationship. It's not an arm's length transaction like going to the store to buy a bottle of water. I give you the money, I walk out. If there is a legal problem that occurred during that transaction, I'm not in an ongoing relationship with the 7-Eleven that I need to be concerned how that's going to affect my day-to-day life going forward. If my landlord has done something wrong, I might have the legal right to hold their feet to the fire until they fix it. But I do also have to take into consideration this is where I live, and they're the people who maintain it and decide what my rent rate is and decide if I get a new lease. So it's complicated. It's never a black and white area of the law, it seems, because all day long, I can advise people on here is what your legal rights are and how to protect them and hold on to those because they're precious, and they are. But I also need to recognize that all these clients need a place to live next week too.
Right. The way that I always deal with that conversation with my clients is I say that a landlord-tenant relationship is a long-term relationship like a marriage. And there comes sometimes in some marriages where your feelings are that, throw gasoline and matches and just burn it all down. But a lot of times if there's issues, you gotta work through it together. And I'm the guy that happily, throw gasoline and matches and burn it all down, and I'll help you do that if that's where you're at. But if that's not where you're at, you sort of like, these are the options, but think about how you want to use those tools to achieve your goals.
We do have some questions online, if you don't mind.
Please.
yeah.
Okay, how does Washington determine where someone serves their sentence? For example, in Oregon, all sentences over 1 year are served in state prison.
So that's principle is generally the same every year, so everywhere. So if you're serving a sentence in custody for a year and a day, and you have a year and a day to go after conviction, you're going to go into the state system. The state system tends to be organized by what they believe the sort of danger severity of the people that they're interacting with are. So you have maximum security prison in Walla Walla. You have medium security prison in Monroe, north of Seattle. And you have low security or minimum security up on Larch Mountain in East Clark County.
That just closed.
Oh, it just closed. I did not know that.
That was the whole impetus for this book, because they closed it in October.
Interesting.
And people were very upset. So we don't know where the minimum security is now.
Right, right. And then there's also transitional facilities that are sort of stepping you up into prison or stepping you down out of prison, like in Shelton. But and one of the interesting things is, it's common in the criminal justice system for people to say the worst time is jail time. I've literally seen people take longer sentences to get into the prison system and out of the jail. So it's sort of
Facilities and services aren't set up for long-term.
right.
Yeah.
And the funding level and quality and sustainment at the state level is much greater. They tend to have more rehabilitative services. You know, they tend to do just things differently. One of the best examples of this is, well, basically all the counties, except for the counties that have separate corrections departments, like Clark County just formed, the jails are run by just like the local elected sheriff. And it's just, you know, an extension of that policing function. Whereas the state corrections department at one point, I don't know if they still are, but to run the state corrections department, Governor Inslee appointed a clinical psychologist because the largest concentration of people suffering severe mental illness in government control is the state corrections system. And so he wanted somebody to manage that system that understood that and could address that.
I do want to ask, do we have a lot of questions? Because as you can probably tell, if you let us, we will run on about every topic you give us.
It's billable hours, right?
Hey, we're all pro bono.
There's just two more, I think they'll be quick.
Well, I just don't want to not get to somebody's because we just keep.
Got it,
going.
no, we've got the two. Okay, so how does Washington determine where an individual is released to? For example, did they get released to the county where the crime was committed?
Once you're released, you know, you're released and they're going to try and, you know, where are you going to end up? Like, where are you gonna live? Oftentimes there's still some parole or probation going on. So oftentimes you can't leave the state of Washington without sign off from a government parole officer, probation officer. But, you know, if you're going to live in the community where the original crime occurred, then you're probably going to receive transitional services somewhere close to that.
So do they get to choose? Like if you have, like if you committed your crime in one part of the state, but you have family in the other part of the state, do you have any say in terms of where you get released to?
The degree of say there is beyond my scope.
Okay.
But ultimately, one of the things that's protected by the US Constitution is the right to travel. So, yeah.
I guess, yeah, is it, like, part of the question, I don't know the answer is it like they show in movies, walking out the front gate of a prison? Or is it, yeah.
There's usually, so you have facilities like Shelton, you have facilities like halfway houses that are in the community.
Yeah.
That are run by the Department of Corrections, that are part of your in custody time, that are intended to transition you back to the community. But the assignment to that is, you know, based upon what the Corrections Department sort of understands between its resources and what's going to successfully transition you. I don't know what the specific ways that they're choosing that.
Okay, one more question.
Go ahead.
Clark County has one of the highest eviction rates per capita in Washington state. In addition to lack of resources for tenant defense, What are specific challenges or problems in Clark County that have led to such a high eviction rate?
Wow, what a question.
Excellent,
What a
excellent
question.
question. These are the things we ask ourselves a lot. In some ways, we just don't know. And we theory craft on what is causing this, what can we do to address this? There's a number of things. We have seen a knock-on kind of property boom from the popularity of the Portland area that has outstripped income pretty tremendously in this county. And anytime, the price of property goes up, the people who buy that as an investment are gonna pass that cost on to consumers. And, no one decides if they're going to have housing or not. You pay for it if you can at all possibly in any way pay for it. So it's not subject to normal market forces that might keep a price down because someone's going to choose an alternative. If, one brand of milk is too expensive, someone's going to find the cheaper brand. There's a severe, or just not have milk, they can avoid the dairy. There's a severe lack of those options in housing. Some things we see, various members of our community, various sub-communities within Clark County, for a number of reasons, tend to be more heavily impacted by eviction. A lot of that has to do with language access. We have certain communities, whether they are common ones we see here, the Islander or Turquoise community, the Latino community, the Russian-speaking community, where it's just having that ability to communicate clearly with your landlord, knowing the norms of the American kind of housing and rental system, access to the courts and understanding what's going on there, access to resources for learning how to be a good renter, how to protect yourself, what are the rules. Those things are much more limited. And so we see those groups very much disproportionately overrepresented in eviction cases. And though we are similar to the Portland area, a very disproportionately white area, we do see that people of color of all types are much more heavily likely to be evicted. And similarly, that economic opportunity for those same groups is, as it is pretty much everywhere here, less. And when you combine that with the economics of Clark County in the past decade or so, you get this really unfortunate mix of the same groups of people, the same individuals, unable to get the resources they need to maintain stable housing where it's so expensive here.
Just to expand, to add to that, I would estimate, and Ben has probably more accurate figures than I do, because he works with the state and the other organizations that have the eviction defense contracts. But I would estimate between 90 and 95% of the cases that we take are just rent default. And, in sort of to get that out of percentages, that's, between 9 out of every 10 cases or 19 out of every 20 cases being just rent defaults and people having difficulty paying the rent. I see regularly rents that exceed, when my wife and I purchased our first house together, our mortgage was $1,700 a month. I regularly see clients with mortgages with rent north of that.
Yeah, so I really wish I knew the actual answer to that question. if I could blame it on the landlords or the landlord attorneys or one thing or the other, but, you know, we are one of the larger counties in the state, and, I think in some ways people know it's good to live here, and so it's expensive. It's more expensive than it should be to live here. It's unsustainably expensive to live here.
Yeah.
And since rent is the vast majority driver of those cases, I think that's what we're seeing.
Yeah.
Like it's so much easier to defend in a behavior-based case. Oh,
Right.
show me somebody with a notice where their landlord told them to stop doing something rather than to start paying the rent. There's much more to do in those cases.
Right. As long as I've lived in Clark County, I was born here in 1983. You know, Clark County, the phrase that we used to say is drive until you qualify. That this was a community where, whether for purchase or for rent, where, you know, jobs were, you know, centered in Portland as the economic driver, and then you were just driving to the edge of the built-up area until you could afford a home. And, you know, as you know, the big coastal cities keep getting sort of wealthier and wealthier, that drive until you qualify line sort of just keeps moving further and further out until you qualify.
You can't find cheap housing in Camas. You can't find it in Battleground. You can't find it in Washougal.
The gorgeous back too.
Yeah. And
You gotta get out to, I don't know, Goldendale almost before you.
right, like when I was a kid, I remember when the city limits ended at the corner of Andreessen and 4th Plain. And now the city of Vancouver goes all the way to Camas, like actually abuts Camas. And, you know, that when I first saw that coming back from time of schooling, that just blew my mind. But that's
It's an odd W shape, the city of
It
Vancouver.
is, yeah. Totally.
but it's like, yeah, I like to blame my dad for some of that. He's the one that got the part of the sewage problems fixed in Richfield so that they could expand.
Way to go, Dad.
I guess the one big thing we didn't say is a lack of investment in building housing and affordable housing.
Yes,
We're just way behind in building places to live.
Yeah.
yes.
One last question.
One last question.
Were y'all involved, were you involved when people got behind rent and COVID, like negotiating all that, agreements to repay?
Yeah, there is a law that's still on the books, though it has an expiration date that we're past now, that coming out of the COVID moratorium required landlords to negotiate for repayment plans. And so, yeah, we did a lot of that. That was, that allowed us to resolve a ton of our cases, but that's also, a lot of that was reliant on the availability of assistance funding. And assistance funding pretty much ended around the same time all those programs did. Other assistance programs like Section 8 are extraordinarily underfunded. We encourage people to apply for Section 8 if they haven't, because it takes a long time to even have a chance of getting it. Once you get it, by the way, you need to become the best, nicest renter your landlord has ever seen, because if you get evicted, you very much risk losing your voucher. And it took a lot to get that voucher in the first place. So, you know, when I talked about that relationship, it's especially important when you have a housing choice voucher, because you do not want to lose that.
Yeah.
But nowadays, we do still negotiate with landlords, but they don't have to take the repayment plan anymore. So it's voluntary, and some landlords don't do them, some do. Some, it depends on the quality of their relationship with the tenant. So we, you know, when there's a case where we don't have any defenses that we can find, we look for the best benefit that we can get for our clients. Is it time? Is it cleaning up their rental record? Is it trying to do that repayment plan? But we also don't want to set someone up with a repayment plan that they can't keep up with, because then they're going to give the landlord all their money and then have to move anyway when they miss a payment. So it is challenging, and we really do want to educate people on their rights, on being a good tenant, and on what is required of a good landlord. So if people are here or are going to come by the library, we've got some things like little flyers about some of your rights as a tenant. This one is about how to respond to an eviction notice. The big thing is do not ignore eviction notices or court paperwork. Give us a call, seek some help so that you can try to resolve whatever the issue is. Because once the landlord files that lawsuit, it goes on your record. Other landlords can find that, and it makes it harder to move. So if we can get involved and try to clean up that record for you, that's, sometimes when there's no other help to give, that's a lot of help, is to make it possible to find a new place to work.
Okay, we're at time. Thank you guys so much for being here. This is great. Any last things you want to make sure we know before you go?
I'll tell you my 4 rules for a renter. I know we're talking about renting a lot.
No, that's fine.
Actually, I made it 5 recently.
Okay.
So, number 1, do everything in writing with your landlord. I don't care who the landlord is.
Yes.
Keep a copy, put a date on it. Especially if there's a problem or you need a repair, you have to do it in writing or the law may not protect you. Number 2, similarly, take pictures of everything when you move in, when you move out, and if there's a problem. And keep those copies. You'll notice this is me saying establish an evidentiary record, but it's important. Number 3 is I say pay the rent first. That both means budget for it first out of your budget, because it's really hard to get help with rent, but it's way easier to get help with food or clothing or utilities, any of that stuff, gas. You can get help well before you can get rent help. So pay the rent first, but also pay the rent before you start a fight with your landlord, because as I said earlier, if you withhold the rent, you may not have any protections or good outcomes from the law anymore if you're not paying the rent. Number 4, this is a new one, is please avoid money orders. Tons of people pay their rent with money orders. Those can get lost. They take at least a month to get refunded if you have the receipt. Money orders create nightmares. The only thing worse is cash, because you can't get that refunded if it gets lost. Pay any other way. If you have not bounced a check to your landlord in the last 9 months, they can't project a personal check. So that's a good option too. Just, I hate money orders. And then rule number 5 comes up a ton. There's no law against your landlord being a jerk. So remember that, it happens. There's not a legal recourse for that.
The one thing that people find generally shocking when I tell them is that, along the lines that there's no rule against being a jerk, is that discrimination is not illegal as a general rule in the United States. Once again, discrimination for specific reasons is illegal, just like with criminal law. So if I just don't like you because I don't like you, but I like this other person, I am fully within my rights to treat you differently than I treat this other person. And it's only if I say, I don't like you for this prohibited reason, that discrimination becomes illegal.
Unless you're in a mobile home park. They have different rules, and you actually have to apply the rules fairly in mobile home parks, but not in apartments or houses.
Wow.
Yeah.
Wow. I learned so much in such a short amount of
Like
time.
I said, everything ends with it depends.
Yeah.
Yeah, that's the basic rule of exception.
Yeah.
Once you're like, oh, I think I understand, they're like, well, but it depends on where you are.
That's law school, is learning to manage the exceptions.
Right.
The entire class of evidence is learning to manage the exceptions.
Oh my God.
The rule in evidence is that somebody saying something else to you isn't evidence. And then here are the 3-page list of individual exceptions to that rule and the exceptions to the exceptions of that rule.
Everything is hearsay, just most of it has an exception.
That's amazing. Well, thank you guys again so much. We really do appreciate you taking the time to be here. We love the service you provide in the community and really glad to have you.
Thanks.